A client who is walking through the door of a law firm must first picture a patient that is walking through the door of a hospital. Patients go to the hospitals because they have sicknesses, diseases that they want to find solutions to. Likewise, the man or the woman who is walking through the door of a law firm has legal issues, legal concern that he or she wants to find solutions to. So the way you explain your symptoms to a doctor in the hospital, he listens to you and you ask questions to get clarification on what really is the issue or what is wrong with you. That is the same way you are going to interact with a lawyer in his or her law firm. This will enable you become more aware of what the real issues are and how the law views that issue, what actions you can take, and what remedies are available to you. Now, you find some clients very confused when they get to court, either because they have not properly conveyed their issues to the lawyer, or the lawyer did not understand what they are saying or the position from which they were speaking. Now, if there is no clear and intentional communication between a lawyer and the client, that can lead to misrepresentation of facts, which can either leave such a client confused or frustrated at the end of that proceeding. This is because of a recent experience that I witnessed during the proceeding of a particular client, though the action was instituted by a different lawyer who has now left the country. And one thing most of these lawyers or most clients do not understand is that you cannot use fundamental rights action to claim ownership of land. You see why it is important as a client to ask the necessary questions, even when you have communicated your problem or the issues to your lawyer, and then find out what is required to go through with that action. Like I said in one of my previous videos, the court is looking for cogent and credible evidence upon which it will take the decision, because it must weigh on the mind of the court. The court must have sufficient grounds why it will give you the relief or the reliefs that you are seeking for. I remember in one of our matrimonial proceedings, after the final address, before the court adjourned for judgment, the judge had to pause and asked the both counsels to refresh the mind of the court on why the court will actually grant the various reliefs that they were seeking from the court, because it wanted conviction on why they actually came to court to dissolve that marriage and either of the parties seeking for custody of children. So it is not enough to rush to court or rush to a law firm because there is a problem on ground without having adequate preparation on how you are going to prosecute that action in court, because you will look unserious, and the court has all the time in the world to look into each of the facts, each of your pleadings, each of your evidence, and examine them one after the other, just to clear its mind, to convince itself that you have done the proper thing. Because where it is able to create doubt in the mind of the court, two possible things can be expressed by the court. Either that you, as a party who has brought such an action, you want to use that action to perpetuate illegality, or that you are unserious. And it's a terrible thing to be viewed in these two perspectives by the court, because it can lead to a dismissal of such an action. This is Saviour Law Essence. Here we give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself. We'll see you again.